So friends,
Okay.
welcome to everybody. At this moment, we are almost reaching 200, Shetty sir, and many more would be joining. So this appears to be the first webinar where GSTPM is joining with AFTP along with All India Sales Tax Tribunal Bar Association. To find out, Patkarji is not joined now still. He has some technical problem. He would join very shortly. Now, a pleasant task, yes, sir. A pleasant task for me is to introduce today's speaker. Uh, Advocate Shetty ji is an advocate for Supreme Court and High Court, a close friend and associate of many of us. We have seen him in the High Court. Patkar is also has been with him in Rotary, etc. So they had a close associate. JCs, I don't know what. Anyway, Sir has been practicing labor laws and service laws for more than 35 years. He was an HR professional in Union Bank and TCS. Thereafter, in 1992, he started his own practice. He has been giving a lot of training internationally. He is a trainer's trainer. I'm surprised. This is really a good thing. Very good quality. He has been invited twice in Singapore to address the employment summit. And yes, today we are waiting to hear him on a very interesting aspect. Now, coming to the subject, I would just tell 1 minute, I mean less than 1 minute. We received a lot of conflicting views on whether to pay full salary to our employees, how to go about that. There are people who can't afford. Seriously, they can't afford. Now, the best question can be whether Supreme Court can ask us to enforce something impossible to comply with. That is also a pure legal question. I'm sure Shetty ji would be able to answer. He is going to take us through the Epidemic Act, MHA orders, and then his own views. Over to Shetty sir, please. No, sir, before that, may I invite our local association, Goods and Service Tax Practitioner Association, a strong and dynamic association, equally strong President Shri Dinesh Thamleji. Please, Dinesh, over to you.
Yeah, thank you, Nikita madam. First of all, I would like to thank AFTP and mainly Nikita madam for giving us opportunity to join with AFTP for this webinars. And because of this, all over Maharashtra, our members are going to get the benefit of this kind of lectures, which are really value addition in the knowledge. And this lecture, the salary and wages to the employees is really the subject on which people require a knowledge, because now as industries are facing problem, industry will not be, see, we advocates get fees from industries, and in during this period our work is not functioning, and during this period we will also not be getting fees from our clients, and how to then make payment of the salaries and wages will be the big question in front of all of us. And we advocates operate like our staff like a family, is like a family member, but generally, you know, always disputes are there in the families, and when where money comes, there is always a dispute. So how to deal with this aspect is really important, and I would rather say it depends on everybody's individual personal skill to manage this aspect, but we really have to understand the legal perspective of this subject, and therefore this subject is going to be very useful to everyone, and this is going to be a value addition in our knowledge. And I'm really thankful to Nikita madam for giving us this opportunity to learn the subject. Without wasting much time, I request Nikita madam to take a charge and let the speaker share the
So,
knowledge. Yeah.
Ashok Shetty ji, over to you. Salary and wages during lockdown period. His subject is during lockdown period. He would clarify that. Sir, over to you, please.
Start with thank you, Nikita. Thank you for inviting me for this seminar. And I welcome all the participants who all over the country to join us in this session. And I hope I'll be able to contribute something to all of you during this short time that we are together. And of course, the hot topic today is COVID-19 and the implications that it has in all walks of life. As far as our field is concerned, that is the labor and service field, which I am mostly dealing in, is the issue of payment of wages in terms of what the government has ordered. Now, what are the implications? A lot of questions have been asked all over the country, how the wages are to be paid and how we are going to arrange for this, and what is going to be the implication when we start paying the wages and we run out of money. These are issues which are there for most of the employees, whether they are big or small. It doesn't make a difference. And there have been questions after questions have been pouring in from all over the country. Now, therefore, today we will make an attempt to put forward what are some of the issues, how under what provisions they have done, what are the steps some of the people have taken, so that we get a broad view of how we go about in this present scenario. Well, I have a small presentation which I have also brought along with me, and I hope it will save our time in this thing, and you'll be able to appreciate it much better. So, we start with first the MHA order. That is, the MHA order. I hope all of you can see.
Yes, sir.
The
Very
MHA
well.
order. Very well. Thank you, Nikita. The MHA order, which first came on the 24th, actually, and thereafter that was an advisory initially when it came, and subsequently they gave an order on the 29th of 2009, when the salaries were directed to be made to all the workmen without deduction during the lockdown period. Now, that was an order. And a number of issues were there, points were there in that order. But what was more significant is clause 3 of that MHA order, which was issued under section 10(2)(1) of the Disaster Management Act. Now, that clause 3 provides that all employers, whether in the industry or in the shops and commercial establishments, should make the payment of wages to their workmen at their workplace on the due date without any deduction for the period their establishment is under closure during the lockdown. Now, the important points in these words are, first is industry, be industry. Now, all employers, the words are all employees, be industry. Now, this is not an exhaustive definition. Therefore, the word employers means every person who is employing somebody or the other. It only qualifies that whether it is industry or whether it is shop or whether it is commercial establishment. Therefore, one should not say that it is only industry and commercial establishment or shop, because some of the queries that have come forward is whether it's only these three. So the word is all the employers. So that is important, and should make payment of wages to their workers at their workplace on the due date without any deduction. Now, workers, this is the thing. We have broken up into three. All employees and shall make payment of at their workplaces. Now, which is not possible during the COVID time, but that has to be paid on due date without any deduction. Now, these two aspects again to be considered is workplace is one. Due date is the date normally payments are made on the 7th of the month or on the 10th of the month, or sometimes some people pay even in advance who are flush with funds. So without any deduction. Now a lot of people say without any deduction. What did that mean? Without payment of statutory dues like Provident Fund and ESI. I would say no. That without any deduction means to come out to without any deduction because he has not come for work. I'll come to that. What are the legal and permissible deductions that can be made? Now, the deduction regarding Provident Fund and ESI are basically statutory deductions. I would advise that don't go by the word without any deduction. Deduct it, pay it into the Provident Fund and to the government coffers, because nobody is going to complain tomorrow. The government is only not going to say, why have you paid? Then you say, give it back. That's what we can always say. So pay it, otherwise we will be liable for interest and penalty. Maybe you can take the plea that during this COVID that you are not able to pay or something, but once you make the payment of wages, you are what has been lifted in some parts of the country, but it is there in red zones like Bombay, then Pune, and some other places where the red zones are there, Delhi and Calcutta, Tamil Nadu, Chennai. So these are the places where this would continue. Now there is no mention in the latest this thing that it supersede, that this is in supersede, that the new guidelines are in supersession. The guidelines will continue during the lockdown, because this is during the lockdown period. So it will continue, notwithstanding the fact that new guidelines have. Now, various governments have issued advisories and orders under this National Disaster Management Act and the Epidemic Disease Act 1897, advising and directing employers that they should not reduce wages, not retrench, not terminate their workmen, but pay them full wages during the period of the lockdown arising out of this outbreak. That means not only to pay the wages on one hand, but also not to reduce the wages, but not to retrench the workmen, not to terminate their services, and to pay them full wages during this period. So these are the other aspects which also need to be addressed. That an employer cannot retrench or terminate at this point of time. Now, after the lockout is a different matter, which we will come to it shortly. Now, the government of Maharashtra, where I am based, basically, where it has also issued a GR in reference to the workers who are displaced from other states, working in several business shops, institutions affected by the prior directions of lockdown declared by the government of Maharashtra for the purpose of stopping the spread. Now, this is the preamble. Now, and in light of the powers and functions of the state, now the Disaster Management Act has also a national level body and a state level body. So both are in a position to pass orders. Now, the State Executive Committee, there's a National Executive Committee under this, and the State Executive Committee under the Maharashtra State Disaster Management Authority. Now, under Section 24 of the rules, all workmen are either on contract or outsourced workmen, employees, temporary workers, employee or daily workers working in private organizations, industries, companies, except essential services, because they are supposed to come. Essential services, why it is exceptional, because they are supposed to come and work. So if they don't come, the Essential Services Act can be invoked to get them to work. So all these workers, employees, are required to work. Now here, the word employee, now those who stay at home during the spread of COVID virus, they should be assumed to be at work, and these workers and employees shall be paid complete salaries and allowances to which they are entitled. Now, these orders shall apply to all semi-government, industrial, commercial institutes, traders, and shops within the state of Maharashtra. Now, the important part here is the directions do not distinguish between workmen. Now, all of you are aware that labor laws is applicable only to the workmen category. Workmen has been defined under 2S of the Industrial Disputes Act, which excludes supervisory to a particular salary level, administrative, managerial employees, and temporary and casual and contract workers who are hired to a service provider. So these categories of workmen are also, as far as this act is concerned, as far as this order is concerned, would apply to them. Therefore, it is much wider. There is no the word employee has not been defined here, but this should be a person. For instance, in all labor legislation, every labor legislation has a different definition of employee, but the word in the Gratuity Act, a person employed is mentioned, which includes everybody, including the managing director. He is a person employed, including general manager, assistant general manager, everybody. So probably taking a cue from that definition, they must have brought in this terminology. With the result, today, we are supposed to pay, all employers are supposed to pay all the persons employed. Okay. Just a minute. There is now, disaster, under the Disaster Management Act, the definition is before you. It is a catastrophe, calamity, a grave occurrence in any area, results in substantial loss of life and human suffering, and with all that damage to property and everything, and is such a nature that is beyond the capacity of the community in the affected area to take care of it. A question is whether the pandemic, which has been this thing, has not been defined as far as this thing, but it could be considered probably as a catastrophe or a calamity. But no particular this thing is there as far as the pandemic is concerned. But the Epidemic Act mentions it. And we'll come to this definition of punishment if you do not listen. So these are the. A question before us is during this, how do we follow the position that is there? Now, people ask whether it is incumbent upon us to follow this. So, since it has been issued under the Disaster Management Act, there are penal provisions. Now, those penal provisions are first, Section 51 of the Disaster Management says that punishment whoever without reasonable cause. Now, in my opinion, if there is a way out, people say that you must follow. Yes, we must follow as far as possible. We must follow. But whoever without reasonable cause obstructs any officer, now that we will not know to obstruct anybody. Second one, refuses to comply with any direction given by or on behalf of the central government or the state government or the National Executive Committee or the State Executive Committee or the District Authority under this Act shall on conviction will be punished with a term which may extend 1 year or fine or with both. And if such obstruction or refusal to comply with results in loss of lives or imminent danger thereof, shall on conviction be with a term which may extend 2 years. Now, therefore, if you the question of not paying salary would amount to refusal to direction given by the state or central government. So, question now is, supposing somebody is unable to pay, how does one get out of it? Is unable to pay, it is necessary for this thing, whoever without reasonable cause. Therefore, that the window that is available to us probably is to show that we have a reasonable cause where we are not able to pay. You must have seen in the last listing, I will not name the companies, but some of the companies have said, okay, we are going to give 10%, reduce salaries by 10%, and 20% we will be cutting, and we are going to have employees giving. So these are things which are coming on national television also, which you must have seen. So my suggestion would be that we should be in a position where we can show that the employer, that the company is not in a position to pay. Make an application to the bank and see if the bank is going to give you money to pay off this amount. Now, you cannot say that with 5,000 crores of profit, if I declare that I am not in a position to pay. But if your profitability is maybe very little, and if this amount if you pay them, you will be left without any working capital, then of course you can consider that it is a reasonable cost. So therefore, it all depends on the facts and circumstances of each case. Where you are if you are in a position where you can say that I am not I have not been, the company has not been able to pay. Yes, here we are listening. We have a window to get out of this punishment. That's Section 51. Now, what is important is that is a risk one is taking. So, as far as possible now, keeping the letter and spirit of the order that is there, we should keeping the letter and spirit of this order, we should try our best to see whether we can pay or not, because this amount of payment is restricted to the lockdown period only. People are worried. How long is the lockdown going to continue? Whether it's going to continue for 2 months, 3 months, 6 months, 1 year. In which case, the companies obviously would not be in a position to bear with it. And therefore, therefore they were presumably worried about it. Now, offenses by companies. Now, Section 58. Now, Section 51 has to be read along with Section 58, offenses by companies. Where an offense under this Act has been committed by a company or a body corporate, every person who is at the time of the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of contravention and shall be liable to proceed against and punished accordingly. Now, next is, who are the people? So, provided that nothing in this subsection shall render any such person liable if he proves that the offense was committed without his knowledge and that he exercised due diligence. Many times it so happens that the people are at the top may not be aware of what's happening at the grassroots level. In that case, they can be excused. Now, second is significant. notwithstanding anything contained in subsection 1, where an offence under this act has been committed by a company and is proved that the offence was committed without the consent or connivance or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Therefore, what is significant here is director, manager, secretary, or other officer. So all these persons will be liable to be proceeded against. Now, explanation for this is in a company, if there is a body corporate, includes a firm. If it's a partnership firm, also it would be included, or any other association of individuals. And a director in relation to firm means also a partner of firm. So therefore, merely this thing, like for instance, under Companies Act, it should be registered. So even if it's a partnership, it would be considered. Now, the point arises, people ask, can I retrench employees or lay off employees? Now, I don't require them. Can I lay them off, or can I, because my business is not, as it is not going to survive after the lockdown period is over. So can I? So the question is, yes, you can, but not during the lockdown period. Now, two important things which I would like to point at this time is, the question is whether people say whether it is legal, constitutionally valid or not. Now we'll deal with that when we come to the Supreme Court judgments. Strictly speaking, it may not be legal, but as long as it subsists, as long as it is there, today under the Disaster Management Act, you are bound to follow it. Now, the question is whether the powers vested in the Disaster Management Act do not envisage the payment of salaries to employees without work when they are doing this lockdown period. It does not envisage. There is no provision for payment of salaries at all. If you look at the provisions of the Act, it only deals with certain disasters and how to rehabilitate them. Now, the special acts like the Industrial Disputes Act deals with the right of an employer to lay off and retrench. Due to inability to give now the right layoff definition, if you see in the Industrial Disputes Act, it includes the person who can be laid off if there is a natural calamity. In fact, it has come as an amendment to the provision of layoff. And the DM Act, that is the Disaster Management Act, or the Epidemic Disease Act, has no such provision on this subject. Now, as far as Special Act and general legislation is concerned, if there's a special enactment pertaining to a particular subject, that would prevail even if it is an older act. The Disaster Management Act is a different act which has come in the is there that would prevail over the Industrial Disputes Act. In my considered opinion, it would not, because it has no provision for dealing with issues relating to employers, issues relating to. But as again I repeat, today, as the law stands, as the order stands, that order is subsisting and is valid and has to be followed. This is as far as the legal position is concerned. This being a special enactment dealing with layoff, you can lay them off, you can retrench them, but that will be now subsequent to the lockdown period. Now, as far as this is one act which is a special act dealing with lockout and retrenchment. Second is the Payment of Wages Act. In the Payment of Wages Act also is a special act which deals with the payment related to all the employees. So these two acts are special acts which take care of this case. But unfortunately, the government has passed an order which has now been challenged by this thing. Now I'll just come to the just a minute. Now the payment, this is I was looking out for this only. The payment of wages to employees is governed by another special enactment, the Payment of Wages Act, which along with now the Payment of Wages Act actually has been amended, which along with Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration will be replaced by the Code on Wages. Now this Code on Wages has, will be repealing this. In fact, the Code on Wages has not come into force. It has been approved by both the Houses of Parliament. It has received the President's assent, but it has not been come into force so far. There are two other this thing on industrial relations and social security, which have also been this thing, because the present government has decided to do away with all these old enactments, bring about this thing, codify everything together in one under one capsule. So there will be three capsules: code on wages, code on industrial relations, and code on social security. Now, under the Payment of Wages Act, there are permissive. Now, this being a special enactment, there is this deals with what are the permissible deductions. Now, what permissible deductions, for instance, if a person is absent from duty, all of us know he doesn't get paid unless and until he applies for leave. If he has got a leave balance, if he doesn't have a leave balance, he is treated as absent without leave. He doesn't apply. If he has a leave balance and doesn't apply, you can put him as absent and deduct his wages. So, statutory deductions like provident fund, ESIs, proficient tax, all these things can be deducted from an employee's salary. These are called permissible deductions. And from wages can be made under the payment of wages if an employee is absent from duty during lockdown also. But no provision for payment of wages in the Disaster Management Act for absence from duty. Absolutely nothing. There's absolutely not a whisper contained in any of these. Now, Section 72 of the Disaster Management Act provides that it will have an overriding effect over any other law. Now, as I said just now, that a law which will prevail, now this is the law which is 2005, which would prevail, it would prevail in case of inconsistency. So there is an inconsistency, but for it to have an inconsistency, there must be a provision. There is no such provision for payment of wages in either of these acts, either in the Epidemic Act or in the the Industrial Disputes Act does not. Being special acts of the subject, they will prevail, in my opinion. This is an opinion. So, in my opinion, it will prevail over the DM Act. Now, again, one point worth noting is, see, in the Bank of India versus T.S. Kelawala's judgment, which says no work, no pay, has been declared by the Supreme, enunciated by the Supreme Court. And where they said if a person comes to work, like for instance, there are people in banking industry have come to work, but they did not do work. They went outside, started demonstrating. So the Supreme Court says that you can deduct wages, proportionate deduction can be done. So for the period that they were outside, they were not working, you can deduct wages on the principle of no work, no pay. And that has been going, that has been held for the past many years. This is a very old judgment. So, but it has been consistently applied in industry. If a person comes to work, it's not enough. But here again, no work but pay is the order that has come. Now, as I said, various petitions have been filed in the Supreme Court against this order, which according to me would be unilateral, arbitrary, in gross violation of the principles of natural justice and contrary to public policy. Now, it is also contrary to the existing statutes, the Industrial Disputes and the Payment of Wages on the subject, and patently beyond the powers vested under the Disaster Management Act and the Epidemic Disease Act. Now, these orders, according to me, would be unreasonable, irrational, capricious, and therefore would be subject to judicial review. Now, they are contrary to Article 21, dealing with the fundamental right right to life of employers. Now, the question of their very existence is at stake. The poor employers who have put in their lifelong savings, there are people who have put this into business and they are not in a position where they can survive. Now, Article 308, in terms of which a person cannot be deprived of his property, save except with the authority of law. That's what is the compensation that he will get in case you are going to deprive him of his property. So all these issues are before the court. Now, I'll come to the Supreme Court cases which have been found a little later. But before that, I would like, now question is, if the employer does not pay, who pays? Obviously, it is the government which has to find this, because there are so many funds which are there. Today, under the Disaster Management Act, under Section 41(1), the central government has constituted a National Disaster Response Fund. If you which is there, which is called the National Disaster Response Fund, should be enough to take care of all these eventualities. For meeting now, what is the purpose for meeting any threatened disaster, threatening disaster, or and response, relief, and rehabilitation as per guidelines. Next is under section 46(2). The National Disaster Response Fund is to be made available to the National Executive Committee, which is constituted under the disaster management, to be applied towards meeting the expenses for emergency response and relief and rehabilitation. Now, section 47 provides for another fund, and that is the National Disaster Mitigation Fund, for projects exclusively for the purpose of mitigation. Now, this is an academic interest, but then I thought we should know about it, because where else would you? I mean, you would say that okay, if I don't pay, who pays, and from where is it going to come? Now, so National Disaster Mitigation Fund for purpose of mitigation. Now, this is all, but according to me, it will also amount to mitigation of the difficulties of the poor employees. Now, section 48 constitutes a state and district disaster response and mitigation. Similarly, at the level, at the state level also there are separate funds which have been provided for. Now, internet is stable. Now, apart from that, all of you are aware that anytime any national emergency is there, or if there is a war or something, people donate freely, or we have been grown up donating freely to the National PM Relief Fund, Prime Minister's Relief Fund. But now a new fund has been created, Prime Minister Cares Fund, which is called the Prime Minister's Emergency Situations Fund, has now been created where contributions are being collected. A lot of people have been paying over at the national level as well as at the state levels. And so, why should a private employer be made to bear the burden of wages of the employees during the lockdown period without work, when the obligation is of the government, as in other countries which have social security schemes? Now, pausing here for a moment, if you were to take the position in other countries, like let us take, for instance, the developed countries like US, UK, and the European countries which are there, and some of the Asian countries also, where they have welfare amenities. Supposing a person is without a job, during this period, if the employer removes it, he goes to a job. The state takes care the unemployment. They call it dole in those countries, in the US. But what has happened is in America also, probably they had to. They thought everybody will be out of job, have to pay. It will be a burden on the exchequer. Probably that is why they did not have the lockdown as earlier, and because of which the burden has come. The number of casualties have far exceeded what has happened in our country. Now, Europe also, the same system arises. People will be without jobs. But I believe in Australia, something has happened. I just happened to hear on television, Australian television, that they have told the employees that don't move it. We will reimburse you a large portion of the salary. That is what the Australian government has said. Whereas in Europe and other countries, I think apart from Sweden, other countries, they have not done any such thing. With the result, the queues that came up for the welfare for collecting their dole became tremendous, whereas that did not happen in Australia. Now, apart from that, as far as India is concerned, we do not have such a social security system. And a large country with such a large population, it is probably not possible at this point of time to bear the burden. The burden that is there has to be borne equally by the employer as well as the employee. Now, you cannot put 100% burden on the employer, and the employee without working gets the full wages. We can understand now, supposing if there is a suspension of an employee for a disciplinary action, what is paid? A subsistence allowance is paid, so that the employee does not starve. Even in this case, all that the government could have done is given a subsistence allowance. 1/3 is the norm, which sometimes in some cases is 50% after 6 months. So some percentage could have been given so that the employee also shares the burden of this COVID, of the lockdown. And once the employee also works, he also feels today employee most of the company, oh, I don't have to work. Why should I work? I'm going to get paid. So this is the attitude of an employee who would say that, oh, I don't have to go. Even our maid servants, for instance, they are also sitting pretty happy that they don't have to do their regular work, and they not come also. Not that we would welcome employees to come and run the risk of getting it. But never, this burden has to be shared by all. But looking at it from another humanitarian aspect also, it is not that legality on a humanitarian basis also. This has to be shared. The employees, as an employer, if you consider a family, as an employer, you have people working with you for maybe 10 years, 15 years, 20 years. Suddenly you cannot say, now next 3 months you're not going to be there or you're removed. That can't happen also. A lot of people say, okay, he has worked for me for so many years, I should pay him some. But imposing a condition like this on a private employer and making it compulsory at the threat, like forcing or compelling him to make this payment is something which is unheard of anywhere in the world. So therefore, the suggestion that could be there, that could have been there, is they could have imposed a percentage like 1/3 or 30%, 40% or 50%. So that the employees also becomes a part of that entire decision. Now, the petitions which have been filed, the first petition which was filed was basically the Nagarika exports. This petition was filed, the first petition that came up in the Supreme Court was filed by a Mumbai textile mill, Nagarika Exports. And thereafter, Ficus and Ludhiana Hand Tools Association filed for setting aside the MHA order, the Maharashtra Nagarika petition. But they withdrew it, of course, stating that it wanted to avoid conflict of submissions considering the number of pleas in the apex code. That is the reason they have given. I don't know whether how far it is true, but they have withdrawn the petition. Now, apart from the constitution validity, now the one which is there, in which order has been passed, is Ficus Pax Private Limited and Punjab Hand Tools. Now, apart from the constitutional validity contained in the MHA orders, whether it is arbitrary, they said arbitrary, illegal, irrational, unreasonable, contrary to the principles, provisions of, including Article 14 and 19(1)(g) of the Constitution of India. Now, this once it's held it's arbitrary, irrational, unreasonable, then it is subject to judicial review. Now, the MHA orders, it is also contained in the petition that the MHA orders would an otherwise stable and solvent industrial establishment, especially small-scale industries, would be insolvent and would lose control of the business, which is a valid reason again. Then they have also contained it, Ludhiana Hand Tools have contained that the MHA order of so under the Disaster Management Act is violative of Article 14, 19(1)(g) and 300 of the Constitution. Permit that to deduct wages of employees who do not have duties in areas. At that time, in all over India, the lockout was in existence, and yet the High Court passed this thing where restrictions are relaxed after the lockdown. Then you can deduct the wages. That means if the employees do not report for work. So as far as we are now concerned is during the lockout period you can't do anything, and Justice Guge also refused to intervene in the alignment petition on the ground that the Supreme Court is dealing with this similar cause of action, and therefore I would like to interfere with this give any relief. But it said that direct wages who do not report for duty in areas where the lockdown is lifted. So today, as we stand, all over the country, in many cases, orange and green zone, there if an employee who has, so now there are a lot of employees who are on the way, they wanted to go, they may not come back. So in respect of this, you need not continue. As far as aligned movement is concerned, they declined to be on the ground that the Supreme Court is dealing. Yet, in spite of the fact the Supreme Court is dealing with the issue, he said once the lockdown, this is as far as the order was as far as the lockdown is concerned. Now, he said that we would expect to pay the gross wages to the employee, except the conveyance allowance and the food allowance, being paid on a month-to-month basis in case workers are not required to report for duty. That is, presuming now these allowances. Now again, the question is how does one interpret conveyance allowance and food allowance? Now, the Supreme Court in the judgment of Surya Roshni has said that they also form part of basic wages. So those allowances which are paid, special allowances which are paid to an employee, if it is paid month by month and across the board, it is to be considered a part of wages. But this probably would be where an employee is paid a conveyance allowance and food allowance once he comes for work, not otherwise. So therefore, maybe on that context, the court has allowed that they need not be paid. But it should not be taken that there are other allowances, washing allowance and other allowances, they need not be paid. If an allowance is being paid to each and every employee across the board, then that should be considered as part of wages, and there should be no deduction of such this thing, of those wages. So anyway, that issue would come only as far as those people where the lockdown has been lifted, not other. Otherwise, you have to pay the full thing. Now, Kerala High Court also has issued Kerala government in fact issued an order to the finance department to deduct 50% of the wages and for a period of 5-6 months, which has again been stayed by the government. Then, as far as these two petitions, we have dealt with it. And the national, now another thing is, if you are aware, most of these media houses, surprisingly, media is in the forefront today, and a lot of people are required in the media, journalists and all, to cover the issues. Yet, I am surprised to say that a number of media personnel are being asked to give in their resignations, are being asked to go, and with the result, the National Association of Journalists have filed a petition in the Supreme Court against the salary cuts, non-payment of wages, job losses in the media broadcasting industry. Order. They are relying on the order. It is the other way. The other petitions are challenging that order. The Supreme Court has issued notice to the media house, and also they have told the central government also to respond on this. Then Twin City from Bombay and New Bombay, they also filed this thing on 30th of April, relating grant of stay for these medium, small scale industries, micro, small and medium industries for the operation of this order. But no stay was granted, and they said you pay for MHA order says you pay full wages. Now, the instrument and chemicals, these are 11 medium and small scale industries who have contended that they are entitled to lay off and retrench the employees. Now, you are aware that small scale industry will not survive if they have to pay continuously for a given length of time, especially in a city like Bombay or in Calcutta or Delhi. Now, they have contended that under the Industrial Disputes Act, there is a provision for layoff and retrenchment. Why should we not be allowed to do it? We will comply with the provisions of the Act. The Act permits you to do so, and this thing should not be. Now, again, an order is issued by the Ministry of Home Affairs. Whether that would prevail over the existing law is another issue. Now, under Section 25M of the ID Act, there is no bar to lay off or seek permission from the government if such a layoff is due to a natural calamity. The government cannot legally override contracts between employers and contractors for contractual work. So these are two contentions that they have taken. Other contentions are that the obligation to pay wages is on the government and not on the private employers, and that these orders are contrary to Article 300A of the Constitution, in terms of which no person can be deprived of his property. Now, this would be amount to depriving of an employer's property. He has to pay from his pocket whether they are working or not. So, by way of enforcement of orders, the government is compelling the small-scale industry to bear an expense which is otherwise the government's obligation and not of the small-scale industry. Now, two concepts which I would like to say and which has been coming off and on. For instance, in various buildings there are holdings and all which are there. There are various other which are contractual. Now, in many of the contracts, you have this clause, force majeure, which means that an event of circumstances which is beyond the reasonable control of a party and which makes the party's performance of its obligations impossible. Now, this would be a clause which normally people would just not have a second glance. But today it has assumed great significance. And the first thing I ask is now if a service provider is giving service to a company and he says The company is saying now from tomorrow I don't want you. The service provider has to pay his employees. He is the employer for the employees. But as far as the principal employer is concerned, his relationship is based on a contract. So if there is a clause of force majeure, then in that case, he can always say that such a circumstance has come and I will move that. Several companies I am told that the principal employers have told their service providers, no, we don't want you from next month, and as and when we want, we will call you. Which again puts the liability for payment of wages on now. That is a matter which is still doubtful whether the principal employer not paying the contractor or the service provider would amount to violation of that act of the government order. Is again there's a grey area which we have not really been able to find out what would be the correct position. But it is a risk that they are taking. So therefore, as far as this is concerned, this clause can be utilized. That can be utilized even after the lockdown is over, not necessarily now. So, for instance, if you are not in a position to continue your business, then you can invoke this clause and say that from now next month I don't want your services. But that would be after the lockdown is over. The next is the doctrine of frustration. Now, this is a law that recognizes that if either party cannot fulfill their contractual obligations which have been performed, because the circumstances are such that it would render it, the performance would be radically different from what is mentioned in the contract, and this also could be invoked. Though it may not be, most of the contracts don't have, but under the Indian Section 56 of the Indian Contract Act 1872 explains the provision of supervening impossibility leading to the doctrine of frustration. So that also can be invoked, but that is of course later on. We have dealt with this reasonable cause. I've already said is a window that we can. So question therefore is, can financial inability to pay wages be a reasonable cause? Is a $1 million question. To be that is one thing that tomorrow, because see, I mean, there are some employees who cannot. I will not get it. Big industries may get even if he has crores of rupees as loan, he may be in a position to get that. All of us are aware. But if a small employer goes and says, I want loan to pay salary, you say, what have you got? You are not given any, and you don't have any security to give apart from what you have already taken. So that would be a financial inability. The bank says, no, I can't give you. Then where do you pay from? You cannot even get money because you have kept everything, your entire factory is the bank, everything else is mortgaged, and there's nothing. So question is, can this $1 million question will have to be answered by the other. The next concept that has come into this thing is work from home. Now in India, this concept existed from times immemorial. All of us are aware. The man who used to weave used to do it at home. The potter, the kumbhar used to make the pots at home and then go to the marketplace and sell it. So this concept of work was there, existed from times immemorial as far as India is concerned. And it was there till the industrial revolution in England came, when the factories were established in England and the industrialization came, and being a part of the factories were established even in Bombay to their workers and the artisans and the weavers and everything were moved to the cities where the work was available, and that they started that factories were established. And the various problems. Now, work from home is a concept which one of my friends has spoken on it, which Advocate Vijay Vaidya, and some of the points I've taken from him. Now, various issues and problems are to be addressed before formalizing this concept. It's easy to say, okay, we'll work from home. Everybody cannot work from home. And even those who are working from home, there are various problems that are there. And before formalizing this concept, because our contract today, our contract of employment, is basically establishment centric. Question is, he has to come to work. Once he comes to work, then the question, all other things fall in place. Because now various other issues are there. First is issues are hours of work. When he works from how many hours? Does he work 24/7? What about the flex timings that are available? Office visit. Does he visit the office daily? Transfers. Where does he get transfer now? There is a question of transfer from here to another place. The privacy. Now, there are people who stay in one room. Even if they stay in 2 or 3 rooms, Now, those rooms are available for the family. So disturbance of family members, the paucity of space at home, then the other social factors are the teamwork. If I have a team which I have to work with them, how is it possible? It may be difficult to work from home. But then interaction with my colleagues, superiors, then the chain of command, superiors, the colleagues, the chain of command whom they report to, then what are the disciplinary actions that can be taken against me? What are the misconducts that I can commit at sitting at home? The infrastructure facilities, even today to hold a program like this, we require a computer, we require this thing. Then, in my view, new rules would have to be framed. It will not be easy for us to just say, okay, work from home. That concept will have to be given a thought to, because as I said earlier, that most of our appointment letters are depend upon work coming to a workplace. And with the advent of computers, the advent of the internet, today we are able to work at home. We are able to sit at home and do some work, but it cannot be totally at home. Because, now today in India, for instance, a lot of back office work is done by us here, and just a lot of back office work done here, and people work in the nights because to cater to the American or European population. Similarly, here also work at home is the timings that is going to be, whether your boss will send you an email throughout from morning to night. Is there going to be a fixed time, or is he going to say keep on right throughout the night? He's going to send you, and you have to keep on replying to those mails. Whether not replying to the mail will amount to a misconduct. All these factors would have to be taken into account. Now, next is which Nikita has told me to talk something about the chartered accountants or a tax consultants premises and office. This thing would be a business attracting commercialists. Now, you are all aware that every shop and establishment which is there, any industrial unit, either it is covered under the Factories Act or under the Shop and Establishments Act. Many of them. Of course, there are some exclusions like Nursing Homes Act, and then some others are there. So, but most of it will be covered under the Shop and Establishment Act or under the Factories Act. But whereas establishment of advocates, chartered accountants, tax consultants, and architects, engineers, these there was an attempt in 1977 to bring it within, because a number of the decisions had come by that time, whereby the various courts in the country, including the Supreme Court, had come to this thing that establishments of lawyers and this thing are not which are covered under the Shops and Establishments Act. And therefore, they brought in a special legislation in 1977, 64 of 97, that is, whereby they sought to bring in legal practice in Maharashtra, for instance, bring in acts of legal practitioners, medical professionals, chartered accountants, tax consultants, architects, and engineers within the purview and ambit of the commercial establishments. But that was set aside. And as on today, the main reason is under Article 19(1)(g) of the Constitution. We have to go back to the Constitution, which guarantees all citizens the right to practice any trade, business, or profession. Now, they have maintained a very clear distinction between carrying on a trade or business as against practicing a profession. So, therefore, practice any trade, business, or profession, the profession has been kept separate. And that has come in the judgments. Now, Supreme Court in National Union of Commercial said that the services rendered by a firm of solicitors were only in their individual capacity of the partners and were dependent on their professional equipment, knowledge, and efficiency. In V. Shashidharan, which even holds good even today, 1984, Supreme Court has said that the office of a lawyer or a firm of lawyer is not a shop or a commercial establishment under the Kerala Shops and Establishments Act, which is applicable today in most of the places all over the country. Now, as far as chartered accountant, there was a special this of Philippos and Company versus State of Karnataka. Karnataka High Court judgment, where the office of partnership of a CA is not a commercial establishment under the Karnataka Shop and Establishment. Carry on as CAs carry on profession like lawyers or doctors and do not carry on trade or business. Now, in Philippos, it also the vocation or occupation requiring special, usually advanced education and skill. The work and skill involved in a profession is predominantly mental and intellectual rather than physical or manual. This is the observation in the judgment. Karnataka now recently, this case, after 77, they came, then matter Supreme to the Bombay High Court also heard matter. I think that was in the any merchant's case, which struck down that judgment as constitutionally not valid. Now, subsequently, these are two later judgments which have come. One is Singhvi Dev Unique Accountant Person Director ESI Corporation. Now, whether ESI is covered by ESI or not, and they said no. Ferguson also, Ferguson, which all of you are aware, is one of the largest chartered accountants firm. Now, in 2009, this judgment has come, which says that a chief office is not and therefore cannot burden under this. Now, the other judgments are that in case in a particular this thing, but nothing to do with the other. But as far as this is the law today, as it stands, is that our offices are not shops or commercial establishments. As I said, the entire gamut of laws which are there in the country, the laws are there, are all old. If you look at the Trade Unions Act is 1926, then the payment of wages is 1936. Of course, other two are, but the Code on Wages, which has now received the President's assent in August 2018, after not from both the House of Parliament, has replaced 4 labor laws: the Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and the Equal Remuneration Act. Now, this has given a lot of the changes are wide and far-reaching. Now, this is neither the time nor this place to go over that. We can do it some other time. But it has brought in employees who either never covered. Managerial employees, all these things are today going to be a part of the Code on Wages, and that is going to be a substantial change. In fact, a dynamic change which has taken place as far as this is concerned. This has not yet come into force. It is because it is not yet. And it's to raise 3 labor laws: Industrial Disputes Act, Trade Unions Act 1926, and the Industrial Employment Standing Orders 1946. Now, apart from this, the Code on Social Security. Now, it seeks to establish 9 laws related to social. The most important are there: Provident Fund Act, Maternity Benefit Act, Unorganized Social Security Act. Maternity benefit, all of you are aware that every establishment now has to keep a creche where there are 30 or more employees. That's another 30 or more employees, not necessarily female employees, but 30 or more employees, a creche has to be kept. Of course, in view of the paternity and maternity laws, this, I think probably with that thinking it has been kept. Nevertheless, there are 9 laws which are going to be changed. Now, but they have not come in. While the code is not yet has come into force, both the other codes are referred to a standing committee of labour headed by Mr. Mahatab MP, who has invited views and suggestions. So they are still to come. Anyway, this is all now. I think to Vinayak Patkar, Nikita, for inviting me to share my views, and Rita Joshi and Gaurav Shetty for their valuable inputs.
Thank you very much. Bhavya Bhai, can you share the questions with him?
Yes, ma'am. Yes,
Shetty ji, Mr. Bhavya will read out the question. Okay.
Come here.
From the chat box, Bhavya.
Yeah. I'll take off the share.
Yeah.
Yeah.
You can move so that
Yes,
your
I'm stopping the.
Sir, now I think the video can work now.
Yes, we can try.
Question will come written down.
Yes, I'm reading the questions.
Yeah.
Yeah. So the first question in the chat box was that is housing society liable to pay gratuity to security person, watchman, etc.?
The housing society, cooperative housing society, is not an industry. Whether it's a housing society or whether it's a commercial society, industrial estates, there are judgments of the Bombay High Court itself which says that a housing society is not an industry. In fact, Som Bihar, which is from Calcutta, this judgment which went to the Supreme Court, they said that housing society by itself is not an industry, and therefore the labor laws are not applicable.
Thank you, sir.
Similarly, that similar issue came up in Bombay High Court also, where the judgment is Kiran Industrial Estate Premises, in which I happen to appear also, where it has been held that an industrial society, though it has say 100 or 200 members, each one of them is a commercial establishment. But together, because of the communality of interest that is being done, it is not an industry. Together jointly as a society is not industry, though individually they may be industries. So question of gratuity also would not arise.
Thank you. So the next question is, what about hospital? If the hospital is working, but the employee does not report on duty, do they need to pay salary?
Employees, see, if it's an essential service, ESMA is there.
Yeah.
ESMA, now it is ESMA, Essential Services Act, where they say that if a person does not come, he is liable to be criminally prosecuted. So if he doesn't come for work, one is he is not going to get wages, and second is he is liable to be prosecuted also.
Okay, thank you. So the next question is whether the domestic servants like Kamwaliba, etc., need to be paid for no return during April 20.
Kamwaliba is the most important part in anybody's life. So all of them have to be paid. We are employers. For all practical purposes, we are employers. Now we cannot say that whether we are in industry or not. Even in housing societies, we are employers.
Okay, sir.
This is for the lockdown period, as far as that order goes as on today. As long as that order subsists and the Supreme Court has not struck it down as constitutionally not valid on the basis of all those points which I have taken up, till that time you have to follow the law.
Thank
you have to pay.
So the next
Kamali
question.
Bai Kamali Bai also under the new code on wages, she would be a part of the employee. But that you will have to now. Domestic servant will also be brought within the purview of employee under the new code on wages. The new amendment that has come.
Okay. Sir, an employee is gone on leave on 10th March and was to resume work on 16th March. He did not turn up for work after 16th March and thereafter lockdown was put in place. I was to deduct salary proportionately for the period for the leave. Do I need to pay the salary to him for the lockdown period as he has not resumed work after leave?
Yeah, you can see, take the benefit of him not coming up, being on the roll as on the date of this. You can take the benefit. But tomorrow he may challenge it, but you can successfully probably say that up to 16th he did not come, he was not on the roll of the company. He's a permanent employee, I presume. So you can take the plea that he did not report back for work up to the 16th and therefore there is no question of payment of wages to him. But otherwise, all those who are on your rolls as on the last date of the 24th, the Janta curfew was declared, and subsequently on the next day, the Maharashtra government declared the curfew. So that continued, and on 25th, this order came in. So after that, all would have to be paid. But as far as this employee who is not reported on the 16th, I mean, we can take a plea that he was not on the roll on that particular day, and therefore, so now for extension. Has he applied for extension of leave? Hello?
Yes.
Has he applied for extension of leave? Hello?
Yeah, there is no such mention in the query. Bhavya, you can move on.
Okay, next.
Bhavya,
what is the next question? What is the next question?
Okay, Bhavya, are you not at uska contact is Praful Joshi.
Joshi sir, you need to unmute yourself, please.
Who else is there? Patodi sir is there.
Patodi sir.
Shivram sir is there.
No.
Can I speak?
Yes, sir, you're welcome.
Mr. Shetty,
Okay.
I must compliment you.
Unmute Dr. Shetty, please.
Yes, just
Yes, PC Joshi sir, aap bolo.
Yeah, Mr. Shetty, I
Shetty
must
sir is not having the audio video, sorry.
making us
Please
aware.
unmute me. Take minute.
Okay.
PC Joshi, please wait.
Yes, sir, he is unmuted now.
Okay. Yes, you can speak, Joshi.
Mr. Shetty, I must compliment you for enlightening us on the enactments with which we are normally not concerned or we are not practicing. But
You are mostly with figures.
but my query is this:
Yeah.
that the fact that the order speaks of the employers
Hmm.
as a class,
Yes.
will it not be feasible for the employee to say that you are an employer, though you may not be a Shop and Establishment Act covered by Shop and Establishment or Payment of Wages Act, etc., but you are still an employer, and therefore you are bound to pay the salary during the lockdown period. I, for one, would say, after hearing you, I would come to the conclusion that nothing is payable by us. But the expression, the employer, is very wide, and it is followed by
No,
the
today,
examples.
just
It is
a minute. I did point out.
Yeah.
I did point out that that the word employer which has been used does not restrict the definition to 2S of section of the Industrial Dispute Act, and therefore the employee. So the employee would mean each and everybody, including your managerial staff, your other staff, and all staff. And an employer means a person who employs, including chartered accountants, including advocates. We are supposed, including your domestic servant. So everybody would fall within this definition of employer and employee. Whoever is paying salary, whoever is employing somebody would have to pay, because the Disaster Management Act does not qualify anything. Nor does the order that is passed qualify or define who an employee is. So
So we have
therefore,
to make the payment.
yeah, you have to affect. See, as I said, chartered accountants should not be covered by definition. That is a different aspect altogether. But that is after the lockdown. Today on the lockdown, we are employers, whether we like it or not. Even domestic, when domestic servant issue came in, even domestic servants were required to pay because they are also employees. No definition of employee has been given that he is only a workman under ID Act. Therefore, employee. As I said, Gratuity Act, I pointed out, person employed includes the managing director, general manager, assistant general manager, everybody. So gratuity, everybody is entitled today in law. So probably a similar definition is going to come in the code in the near future for other industrial disputes.
I hope to have pleasure of meeting you at the Bombay High Court.
Yeah, certainly.
Yeah.
Sir. Good name, sir?
He is PC Joshi.
Oh my God. Sorry, sir.
Oh, my uncle and Kshiti's uncle also. Mr. Joshi is close friend of Kshiti Joshi.
Shetty is a good friend of mine.
Thank you.
Yes,
Oh,
Okay, go on. Bhavya bhai, next
Yes.
question.
I was saying I remember having seen, but sorry, sir.
It will be a pleasure for me to meet you in
Right.
person at High
Yeah.
Court.
Give my regards to Sitish.
Yes, I would.
Sir, the next question is:
Yes.
would charitable trust be considered an AOP for DM Act?
For
DM Act,
Charitable trust.
charitable trust.
AOP, charitable trust, even AOP would be considered for this purpose. Anybody becomes an employer. If they are employing people, they would have to pay. Charitable trust, in fact, is covered in the definition of Shops and Establishments Act also.
Okay, thank you, sir.
Yeah.
So the next question is:
if you see the definition of commercial establishment under the Shops Act, it includes a trust whether registered or not.
okay, sir.
So therefore, even if it's not registered, if it's
Okay.
the AOP.
Yes, sir. So the next question is: if an employee goes on leave for 2 months from 15 March and then the lockdown is imposed, would we be liable to pay the salary during the lockdown period?
He has applied for leave. No, on the contrary,
Yes.
for his leave will be debited. You cannot force an employee to go on leave. There are some companies which are forcing employees for furlough to go on leave forcibly. That you have got 3 months leave, you take leave now.
Okay.
Which is not correct. You cannot force an employee to go on leave. But if he himself has gone on leave for 3 months, then that is his problem. Because on the contrary, if he has gone before the lockdown, he did not envisage that the lockdown will come and he will get free. He'll have to. I mean, he would have got even otherwise the wages.
Thank
But
you,
here
sir.
you can debit his leave.
Okay, thank you. So the next question is: will this provision applicable for all level employees from junior to senior to junior most?
Yes, yes. As I said, no, the definition of employee has not been mentioned in the this. It does not restrict, the definition of employee is not restricted to an employee under Section 2S of the Industrial Disputes Act. So therefore, it will cover person who is employed, person employed as per the Gratuity Act, anybody, right from peon to managing director. And employer would be everybody, including a person who's employing a domestic servant. He's an employer.
Last question. Last question.
Last
Any
question, sir.
problem.
Last question.
I have one question.
Yes, sir. Please. He's
Nikita
our
ji,
past president.
It's a Patori.
Yes.
yes, I have one question.
Yes, sir.
You have Mr. Shetty, you have deal with the wage and salary. But what about professional fees? Retainership monthly, quarterly or yearly may be given by the company. And for this period, can they deduct it?
Yes, sir.
Professional fees.
Also,
May I explain, sir? May I explain, sir?
wages.
Sir, what happens
Yeah,
is sometimes, let me explain, sir. Sometimes there is a retainership fee. Hello?
Pardon?
Let me explain, sir. Sometimes there is a retainership fee
Acha, ठीक.
per month given by the companies for procedural work, practical work, legal work, everything. Now, during this lockdown period, can the company says that you have not done any work, therefore sir, can you mute him, Bhavyaji?
Yes.
He can't hear. Okay, so the issue is whether the companies can say, or the partnership from where they are, that during this lockdown there was no work, therefore we will not pay you retainership. I think that's a question.
See, that all depends on your contract of employment. See, there is no relationship of employer-employee.
Yeah.
Correct? There is no relationship of employer-employee. Your retainership is governed by the principles of your contract. If there is a force majeure clause, you need not be paid. Or even otherwise, this doctrine of frustration would apply, whereby you are not capable of delivering your retainership, whatever obligations you are supposed to give. It is it's a contract basically. It is not an employer-employee relationship. In fact, today I am also advising my clients who are on retainership with me through internet.
Yes.
A lot of clients who ask various queries. In fact, at one time there are so many queries. I said I'm going to answer a 3-hour paper.
That's true. That's true.
Some 18 questions. It take me 3 hours to answer this question paper.
Okay.
Yeah. Any other?
Patodi sir, anything else?
Thank you. Thank you.
Okay, sir, be there with us. Patodi ji, please be there with us. Shetty sir, aap bhi jara rahiye, because you are here today on a very important webinar today. We have completed 44 webinars.
Oh my God, very good.
All my 5 zones together, all over India. And it's not that we are closing this, but hereafter, because partial lockdown is now coming up for many areas, we will not be having daily hopes like we had every morning the webinars, and we have completed today. Yours is the 44th webinar today. So I would like my past president to bless us for the further proceedings. Can we start with PC Joshi sir? Can you unmute him?
Yes.
My place.
Yes.
As I said in the morning, the All India Federation of Tax Practitioners is today 44th year in existence, and therefore the today's webinar, and that too also 44th, is really a unique feature, especially when it does not relate to the direct and indirect taxes. You will be always remembered, Mr. Shetty. It will be really a compliment, and I compliment the office bearers of the Federation to continuously, practically every day with the webinars, and thereby expanding our knowledge not only to the taxation measure but also to other provisions like cyber law and foreign exchange and all those things. So I think it is a very good plus point, and it's a permanent gain which cannot be destroyed. It's a permanent gain received by everybody for which no capital gain is liable. Thank you.
Okay. May I move to Patodi, sir?
Thank you for your blessings, sir.
Thank you.
Patodi, sir, please.
Mr. Shetty, you have explained the provisions relating to wages and salary and the liability thereof. Actually, the moral duties are there, and on that basis, we are making the payment to our employees. That is most important in this scenario. As regards these activities we are doing, and I heartily congratulate our President Nikita Ben and their team, who has done a wonderful job in these days, keeping busy all of us, and not only the seminar relating to our tax matters, but other laws also. And we are fortunate to have an excellent office bearer this year, and I heartily congratulate all the office bearers who has done this work. Thank you very much.
Thank you very much, sir. Thank you very much for your good wishes. May I now request, I think Patkar has not joined. No, he could not join. There is some connection issue with him. Dinesh, would you like to speak something? Can you unmute Dinesh Tamde?
Yes, sir.
Dinesh, are you there?
No, Dinesh Tam is, yes.
Yeah.
Okay, he's there.
Yeah, I'm there.
Okay, you
No,
can.
thank you very much, Nikita madam, for making GSTPN a part of this webinars. And we expect like this kind of webinars we are going to do jointly, as we discussed some days back.
Yes.
We'll be coming out with the intensive sessions on GST. So I'm happy to be part of it. Thank you so much.
Thank you. So friends, before I give to Shashank Don for vote of thanks, I have an announcement. We are going to continue with this program, but in a different format for direct and indirect tax both. What we have thought with the local association is, I mean, this is subject to confirmation by our office bearer meeting, which is going to be held later in the evening today. We are planning to have intensive study program on webinars, like not a simple lecture of 1 hour and then question answer. It would be not a preliminary section wise also, it would be issue based, and we would be ensuring that most of the participants are also part of that program. And this is how we are going to deal with direct and indirect tax. Of course, the time is something which we need to see, because people are spread over green, orange and red zone. So it's something we need to think very seriously. But friends, the most important part, Bhaveji, can you share the screen?
Yeah.
I request all of you who are not the member of Federation, please become the member of the Federation, for the simple reason, once you become member, you have access to lot of webinars and other details on our website. My membership fee is hardly 2,500. It's a life membership fee plus taxes. You pay that and you don't have to pay anything in future. We have 3 pops up. This I am showing specifically for the persons who are not the member. Number 1 is the webinar pop-up. You can see all my 44 webinar. Actually, my office says it is 45th and not 45. So we are 1 plus, Mr. Joshi. This is a 45th webinar, and all the webinars you will find the PPT and the YouTube link in our website. We also have e-publication on Vivad Se Vishwas scheme, which is free for everybody, whether you are a member or not. And it's going to be updated from time to time. Now, while I am there, I must also say, contribute to PM Care Fund COVID-19 through us. I am only asking 1,000 rupees minimum. You may have paid in so many other places. Pay 1,000 rupees more here. Only request, I cannot mandate anybody. But the noble idea is to give substantial fund to the PM Care Funds. Thank you, everybody. Over to Shashank Don, please. For vote of thanks. Shashank ji.
Good evening, everybody.
Good evening.
President of AFTP, Nikita Madam, President of GSTPM, Mr. Dinesh Tamdeji, all past presidents present over here of AFTP as well as GSTPM, today's speaker, Advocate Ashok Shetty sir, all seniors present over here, and my colleagues. I must thank Nikita Madam to give this opportunity to me to thank Advocate Ashok Shetty sir, who has accepted our invitation to speak on today's very important issue. Sometimes this issue seems to be more serious than COVID-19. But has explained all the provisions under different act applicable to this issue. Also discuss on all the case laws applicable to this issue, and also given few suggestions and discuss on international level also. He has made the issue very simple, clear all our doubts on behalf of AFTP and GSTPM. I thank him for giving this presentation. Thank you. Please give him loud applause.
Sir, we crossed 400 while you were speaking.
Yeah, thank you.
For your
Thank you.
information.
Thank you,
Bye,
Nikita.
everybody.
Thank you for
Thank you.
having given this opportunity.
Thank you.
Thank
Yes,
you very
thank you very much. Bhavya ji, you can end
Thank
the meeting.